Clerk will report the amendment.
Amendment to the amendment in the nature of a
Thank you.
substitute to the committee report for the resolution recommending that the House of Representatives declare William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Buck of Colorado.
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Congress does its work mindful of House and committee precedents. What members have done and said in past instances involving the investigation of a sitting president, appointment of a special and independent counsel, review of a report from the office of an independent or special counsel, and how we review and consider obstruction of justice and ultimately impeachment are all relevant to our work today. Mr. Chairman, as you are well aware, the referral of the Starr report to Congress in 1998 and this committee's consideration of that report in 1998 and 1999 are very relevant to us today. The purpose of today's markup is to ostensibly to conduct oversight, and the insistence of the Attorney General to refuse to violate the law by surrendering an unredacted copy of the special counsel report has led us to considering a contempt of Congress resolution. What is a special counsel report? Is it definitive in its conclusions? Does it reflect one side's views? Is it potentially biased? Mr. Chairman, you said in 1998 that a report of this kind is, quote, a prosecutor's report. By its nature, it's a one-sided report, end of quote. Why then is it so important for this committee to see the unredacted report if it only tells one side of the story? Wouldn't this committee be better off doing our investigation so we can see information that is not one-sided, but instead balanced? Is it critical for Congress or this committee to review 6E materials? There was a time 20 years ago where you suggested grand jury materials were unverified and may not be true and could be salacious. You said their release would be unfair. Why are we interested now in untrue and salacious materials? You said certain grand jury materials must not be seen at all. Given your position, I offered an amendment several weeks ago to protect those materials, and the Democrats on this committee objected and voted against my amendment. Should this committee see the materials on the floor of the House in 1998, you said it would be, quote, grossly unfair to allow members of the Judiciary Committee to see the materials in relation to a report involving obstruction of justice by a Democratic president. In 1998, you criticized members of the Judiciary Committee, suggesting members of this committee would leak the materials. I would note that during the Nixon impeachment proceedings, this committee adopted rules of procedure to protect against leaks. We could do that today, but I would note for the record we have not. Mr. Chairman, in 1999, the New York Times wrote a glowing piece on your opposition to the Clinton impeachment matter. In that article, they wrote that, quote, Mr. Nadler said he was not convinced that Mr. Clinton committed perjury or obstructed justice, but if the president did, the offenses, meaning perjury and obstruction, would not be impeachable, end of quote. So there we have it. Mr. Mueller said no collusion, no provable obstruction, but even now, we have issues that would not be impeachable if they were found to be verified. And Mr. Chairman, I would note that you did suggest in 1999 that impeachment was a, quote, partisan coup d'etat. I believe it is important for this committee to understand and be mindful of its history as we consider today's business. Your past statements related to these issues are as important today as they were in 1998 and 1999. I urge the committee to adopt the amendment to ensure that the report accurately reflects our past positions. I give back my time.
I thank the gentleman for yielding. I yield myself 5 minutes in opposition to the amendment. The amendment incompletely, I should say, mischaracterizes my position of 20 years ago. It mischaracterizes and incomplete also my position today. I, in any event, reserve the right to learn over a 20-year period. I am not going to waste time debating my view in 1998, and I have already stated my views on this matter today. We ought to be focused now on getting the unredacted Mueller report and the underlying evidence for the committee and for the American people. They are of great moment. I'll simply say one thing with respect to what the gentleman said a moment ago. Yes, a prosecutor's report is a prosecutor's report and is not necessarily totally objective. And yes, we should look at other evidence too, but that's where you start. We have to start by looking at the Mueller report and the underlying evidence for it. It's not where we should finish. No one is suggesting that that's the only evidence before us, but it is the start of the evidence. It is essential to the evidence. And as I said, I'm not going to debate my views of 20 years ago, not now. I'll be happy to do it in other forums. I've already stated my position today. I oppose the amendment. I urge my colleagues to vote against it. And I urge my colleagues to do what we can to get the unredacted Mueller report and the underlying evidence for the committee and for the American people so that we can do our job of holding the administration accountable. I yield back. The question occurs, for what purpose does the gentlelady from Florida seek recognition?
Move to strike the last word.
Gentlelady's recognized for 5 minutes.
Mr. Chairman, I wish to speak in opposition to the gentleman from Colorado's amendment. As a former law enforcement officer, I frequently make statements and comments about law enforcement and the Department of Justice. And overwhelmingly, most of my comments are filled with pride and appreciation for the men and women of a profession that I have loved. But Attorney General Barr has betrayed his oath to uphold the law and defend the Constitution. And today, we are voting to hold him accountable for refusing to respond to a lawful subpoena. And Mr. Chairman, we have more than enough reason to be here and to take this action. The special counsel's report documents a pattern of criminal and corrupt behavior and makes it clear that it is not, if it were not for the Department of Justice rule, had the subject of this investigation been any other person, any other man or woman, he or she would have been charged. And shockingly, the report shows the president tried to limit the investigation, fire the investigators, and hide conclusions. Let us also remember that several of the president's associates who were closely related to either the administration or the campaign are guilty of federal crimes. The president of the United States encouraged his associates to hide the truth, illegally suggested that he would pardon witnesses and threatened them with retribution if they didn't protect him. In short, the special counsel's report tells a shocking story of corruption and obstruction. The Mueller report shows motive and means. It documents statements, events, and evidence. However, 48 short hours after receiving the 448-page report from the special counsel, Attorney General Barr rushed to release a letter designed to mislead the nation, knowing that the American people are just busy trying to make a living, take care of their families, trying to stay healthy and be safe. The Attorney General's letter, in fact, was so misleading that the special counsel wrote to the Attorney General saying that the letter did not fully capture the context, nature, and substance of the report, and in fact threatened to undermine the investigation. As a former police chief, a law enforcement officer, someone who worked as a detective and a detective sergeant, I am not angry, I am not ticked off or afraid, but I am deeply disappointed by the top cops of this nation's behavior. Too often, the powerful exploit our system and take advantage of the system and everyone else. But Mr. Chairman, not today. So I do not support the gentleman from Colorado's amendment, but I do fully support the underlying resolution to hold the Attorney General like we would anybody else, excluding the president, accountable and hold him in contempt. Thank you, Mr. Chairman, and with that, I yield back.
Gentleman from California.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized.
Thank you. First of all, I want to welcome my constituents who have come all the way from Orange County to be here to witness democracy, to witness the Judiciary Committee. Good debate on the law, good debate on policy. And I wanted to take a few moments just to let you know what this is all about today. A lot of debate, a lot of discussion, but this is really about that concept that no one is above the law. And we in Congress have the responsibility on behalf of the American people to hold each and every person accountable for their actions and wrongdoing. Congressional oversight. Congressional oversight is what this is about today. Our democratic constitutional systems of checks and balances says that we have to have meaningful, significant congressional oversight. And today, we're debating simply one important thing, which is access by Congress of the Mueller report. Full Mueller report and all the underlying evidence. We're Congress people. Every day we are subject, we review top secret documents. Believe it or not, we can keep secrets. And today is one of those days when we have to make sure that we have access to all the information. The Mueller report, Mr. Mueller, everybody seems to have an opinion at what the Mueller report is about, including Mr. Mueller, who came back and said that Mr. Barr's 4-page statement was not correct. So here we are today, asking to see the full Mueller report. And it's just not about what happened in 2016, and that's not about who did what, when, and how. Sadly, it's about something equally important, which is the 2020 election. I also sit on Homeland Security. The former head of Homeland Security, Secretary Nielsen, before she resigned, she tried to tell the president that the Russians were at it again. And the president did not want to listen. If we are to have significant democracy in this country, we have to make sure that we protect it from foreign interference. And today, getting to the bottom of that Mueller report is the first step in the direction of protecting America, protecting our democracy, and making sure that people in this country are assured that their votes and their elections are sacred. Mr. Chairman, I yield.
For what purpose does the gentlelady from Texas seek recognition?
To say the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. And first of all, I want to thank you for your patience and for your judicious demeanor throughout these proceedings and in working with the Department of Justice to reach an accommodation. I find it very difficult to even bring to words what I need to say today because as a lawyer, a former judge, and an officer of the court, I'm astoundingly and profoundly disturbed that the Attorney General of the United States is refusing to comply with a congressional subpoena. Never in my dreams growing up, working hard to get an education with a belief in truth, justice, and the American dream, never would I have believed that I'd be sitting here today talking about an Attorney General of the United States, the top law enforcement officer, refusing to comply with a subpoena of the United States Congress. And what's this fight really all about? You know, this is the report itself for those watching from TV. And it may sound like it's not a lot when they keep saying that it's only 8% of a report, but wouldn't all of us like to hide 8% of our lives? You know, I stated earlier, what about the truth we tell? I'm Catholic. When I go to confession, do I just not tell 8% of the things that I really should confess about? No, you confess about the whole thing. This is what it looks like. If you're the reader, you really do kind of feel cheated because you're reading and then all of a sudden there's just dark spaces. And that's really how I do feel. I feel like I'm being cheated. I feel like the American people are being cheated. So it's important, Mr. Chairman and my colleagues, that we tell the American people exactly why we are here. We're not here because we enjoy yelling at each other or fighting with each other or frankly, sometimes because we enjoy being with each other. We are here convened today to fulfill our constitutional oversight responsibilities. That, I might add, in addition to legislative responsibilities. The Constitution establishes Congress and the executive as co-equal branches designed to check each other. That system relies on each branch respecting, and I'm going to underscore respecting, the powers of the other two. This committee has issued a subpoena directed the Attorney General to produce an unredacted copy of the Mueller report so that we can see, frankly, what they're trying to hide. We need the full report, but the Attorney General has refused to comply and now belatedly has urged the President to exert executive privilege. In Texas, we say he's a day late and a dollar short. That refusal undermines our constitutional order and its system of checks and balances. And if we do not hold the Attorney General in contempt for this refusal, then it blesses the continued diminishment of Congress as an institution and continues the disrespect to the American people. Congress is constitutionally entitled to the full Mueller report, and it requires this evidence so that we can fulfill our legislative, oversight, and constitutional responsibilities. Mr. Barr may need reminding that no one, not myself, not the President, and not the Attorney General, is above the law. So I therefore think that, Mr. Chairman, that we have no choice but to hold Mr. Barr accountable, and the way we do that is through contempt. I don't support this amendment. I think we need to move on. I don't think it adds anything, and I intend to vote for your motion and your report. Thank you, Mr. Chairman. I yield back.
Chairman.
Mr. Chairman.
What purpose is the gentleman from Wisconsin seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, we've had a number of speakers in a row on the other side of the aisle, and every one of them has forgotten the background of Attorney General Barr, former Deputy Attorney General Rosenstein, and also Mr. Mueller. All of them are prosecutors. All of them are trained to spot where there is enough evidence to obtain a conviction should they go to the grand jury and bring a defendant to trial. In terms of the alleged Russian collusion, there is extensive evidence in the Mueller report that yes, the Russians did attempt to influence the election, but there was no collusion or no conspiracy. You know, they did things like paying Facebook to have pop-up ads on people's cell phones and other types of things, including getting the voter registration rolls in the state of Illinois and perhaps elsewhere. But there wasn't the tie that they concluded with the Trump campaign, or for that matter, anybody else to do that. Now, in regards to Volume 2 of the Mueller report, again, Mueller is a trained prosecutor. Many of the indictments that he brought were for federal crimes of people who were involved in the Trump campaign, like Mr. Manafort, but for offenses that they committed before Mr. Trump even announced his candidacy for president of the United States. So we're not talking about corruption during the campaign. We're talking about corrupt individuals doing corrupt things before Trump announced and before the campaign started. We hear an awful lot about the summary of the Mueller report that Attorney General Barr made public a couple of days after the report was delivered. Now, first of all, you can read that report in a couple of days. It's 400 pages long. So having a reaction to the report within 2 days is not simply blowing off what may have been contained in there. But Mr. Barr is entitled to his opinions. And what was contained in that letter are the opinions of the Attorney General of the United States, no more, no less, on what he had read in the Mueller report. Now, if Mr. Mueller has a different opinion, and apparently he does from my reading of the press, maybe he should have made that part of the report a little bit more specific so that there would be no ambiguity involved in what Mr. Mueller was driving at. Now, we talk about separation of powers here, and I've heard that repeatedly today on the other side of the aisle. One of the things in separation of powers is that the legislative branch does not prosecute anybody. That's a bill of attainder, and that was specifically prohibited in the Constitution simply because of the excesses of the British Parliament that occurred before the Constitution was written and before the independence of our country. So we don't prosecute anybody. Sure, we do oversight, but I can say there's a way not to do oversight, and that's what we're seeing on the other side of the aisle. I was the chairman of this committee for 6 years in the last decade, and before that I was the chairman of the Science Committee. We did very vigorous oversight on the Patriot Act, as the gentleman from New York recognized. I did vigorous oversight of our involvement with the Russians in terms of the space station, as those who were around here at that time recognized. But in 10 years as a committee chairman, I never issued a subpoena. And the reason I never issued a subpoena is that I was able to get the information the committee needed to do its oversight simply by negotiating, by writing letters to the agency head, some of which I admit used some very tart language, but at least I was able to get the information that the committee needed to make the agencies operate better without issuing a subpoena. What we're seeing here is subpoena first and then figure out what we can do to make people embarrassed because they cannot comply with all parts of the subpoena. Mr. Barr can't do that under Rule 6E. So the chairman has put the Attorney General between a rock and a hard place. Comply with a subpoena, you violate the law on grand jury secrecy, blow off the subpoena, and you end up being found in contempt. That's not fair, and it doesn't do this committee any good in getting to the bottom of this. I yield back.
Mr.
For
Chairman.
what purpose does the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. I'd like to move to strike the last word.
Gentlelady is recognized.
Thank you. On the heels of my esteemed colleague from Texas, I'd like to kind of take a few moments and just bring these discussions back to our broader problem. Today, the House Judiciary Committee is holding a vote on whether to hold Mr. Barr in contempt. And trust me, I take no joy in doing this whatsoever, and I'm disappointed that it's come to this. But compliance with congressional oversight is simply not an option. The American people should be able to know if the government is working for the people. And my constituents in my district, they deserve to know the truth. And this committee, we deserve to know the truth. And we should do whatever it takes to ensure that our government is by the people and for the people. This administration has announced a dangerous blanket policy of refusing to comply with critical congressional oversight. This makes it impossible for us and this committee to fulfill our constitutional responsibilities. And lastly, I'd like to say this. If this committee, with every fiber of their being, is not fighting for the American people, then who are we fighting for? And I yield back the balance of my time.
Mr. Chairman.
Mr. Chairman. For what purpose does the gentleman from Louisiana seek recognition?
Move to strike the last word.
The last word is duly struck, and the gentleman is recognized.
Thank you, Mr. Chairman. I have a point of clarification. It's a bit technical, but I do believe it's very important for the proceedings today. Before we recess, the committee voted unanimously to adopt an amendment by Mr. Gates that provided that nothing in the resolution shall require the Attorney General to break the law in complying with the subpoena. And a number of Democrats, including you, assured the committee your intent was not to force the Attorney General to disclose 6E material, which would, of course, be in violation of the law.
Without a court order.
Without a court order. So on April 3rd, this is the question, Mr. Buck offered an amendment to specifically exclude 6C material from the subpoena. And I have the amendment right here, and I'd ask unanimous consent to include that in the record.
Without objection.
Every Democrat voted against that amendment, and I have the vote tally right here as well, and I'd ask to include that in the record as well.
Without objection.
The amendment failed by a party line vote, 16 Republican yeas and 24 Democrat nays. This morning's vote changes nothing about the subpoena and the demands that are put on the Attorney General. The subpoena, as it stands today, requires the Attorney General to break the law to be fully compliant. If you look at it on its face, that's beyond dispute. I know that, and you know that, and yet you are nonetheless rushing to hold him in contempt. So despite your intent that the subpoena not require 6C material without a court order, that's what the subpoena you issued actually demands, if you read it on its face. You and every single Democrat member on this dais voted for that, and that's the danger that we're talking about today of moving forward so quickly on these things. So here's the question. Ask my good friends and colleagues on the other side. How do you explain today's sudden change of heart? Is it true that it is not your intent to force the AG to break the law by forcing him with your subpoena to disclose 6E material? And if that is your intent, that proves what every Republican on this dais has been saying all day. If it's not, then the subpoena you've issued is dangerously overbroad, and the question is, are you going to reissue a new subpoena? It's a change of heart that I think there's some clarification. I'll yield.
No, we're not going to issue a new subpoena. We have no intention and never had any intention of trying to force the Attorney General or anyone else to give us 6E material without going to court. We did want to, and we still do, want to follow the procedure that has been done in every similar case in the past of going to court, which we will do, to ask for 6E material and having the Attorney General go with us. The reason that was in the subpoena was to increase our clout in court in getting the 6E material, hopefully with the Attorney General's support, but in no way meant to force him to give that support.
Mr. Chairman, reclaim my time. The way I understand it, the Attorney General would be required to go to court to avoid the way the subpoena is written right now. Well, he would be required to go to court.
Gentlemen, will yield.
I will yield. Yes, sir.
The subpoena is written as the beginning of a dialogue process, as the beginning of a process to talk to the Attorney General and to the Department of Justice, and ultimately to go to court. But it's designed to be the foundation of a dialogue and is not designed to force our hand in what we insist on in court.
And Mr. Chairman, the beginning of a dialogue, let me yield to Mr. Buck, if I may. Mr. Chairman.
Let me just point out.
Well, wait, this is my time, Mr.
We have
Chairman.
accepted the amendment today. We've stated the intent. I think that should take care of the matter. Go ahead.
This is a contempt proceeding. Let me yield to Mr. Buck.
Mr. Chairman, I've issued many subpoenas or requested the court to issue many subpoenas on behalf of prosecutors' offices that I've worked in. I've never considered it the beginning of a dialogue. I've considered it a command by the court to produce documents. We are now in a contempt proceeding, and I'm not sure whether you consider this the middle of a dialogue or the mid-beginning of a dialogue, but I consider this a pretty serious matter, as is issuing a subpoena from the Judiciary Committee. If it was a dialogue that you were interested in, and I understand that it's your position that you had attempted a dialogue for 2 months before the Department of Justice came to the table, but if it's a dialogue you're interested in, I believe there are other methods of going about that than a command from Congress to the administration to supply documents. And this is a far, far cry from anything other than one of the most serious matters that we will handle in the Judiciary Committee in the year 2019. So I would ask, and I thank the gentleman for yielding to me, but I would ask you to clarify exactly what we're doing here in contempt, if this is part of a dialogue with the Attorney General.
And Mr. Chairman, just reclaiming my 6 seconds that I have left, in the letter this morning from the Department of Justice to you, he says, you've terminated our ongoing negotiations and abandoned the accommodation process. That's a dialogue. Why did you do this, and why are we here if this is part of the dialogue?
We didn't terminate. They did by refusing to make any offer in good faith. The gentlelady from Florida is recognized. For what purpose does the gentlelady from Florida seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I think we need to regroup for just 1 second, and I'd like to share my story. I did not have the privilege of being born into this country. I became an American citizen when I was 20 years old, and both when I became a citizen and when I was sworn into Congress, I took an oath to protect and defend the Constitution against all enemies, foreign and domestic. And just last month, I spoke to a group of new citizens in my district in Miami who took that same oath. The room was in tears at the significance of becoming members of our shining example of democracy. Attorney General Barr took that same oath, but now he shows us that the only oath he's following is to protect and defend this president, who right now is threatening the strength of our democracy. Having come from South America, I understand very well what it means when authoritarian leaders believe that they are above the law. They start circumventing other branches of government and consolidate their own power to the detriment of the democratic ideals and freedoms of this country. And we cannot allow this to happen in the United States of America. We have a crisis in our hands. On the one hand, we have a report that details a systematic attack on our election system by a foreign adversary. On the other, we have an administration that refuses to acknowledge these attacks and fails to recognize the Article I powers of a co-equal branch of government. And we have an attorney general who refuses to comply with a duly issued legitimate congressional subpoena. Now, just for one moment, I'd like to bring up some facts. The Mueller report concludes that the Russian government interfered in the 2016 presidential election in sweeping and systematic fashion. The report states that the Russians attacked our election systems, at least in part to support the Trump campaign. The Russians targeted our state and local governments. In fact, my own state of Florida, including my very own district, Florida 26, was a victim of Russian attacks. The report says that the Russian government sent spear phishing emails to over 120 email accounts used by Florida county officials responsible for administering the 2016 election. And despite this clear threat to our democracy, the Attorney General has seemingly relinquished the duties he owes to the American people. He has chosen to work as the president's personal defense counsel, seeking to bury Mueller's very detailed accounts of the president's attempts to obstruct justice. Since Mueller issued his report, Mr. Barr's conduct has been misleading and defective and deceptive. He's tarnished his own reputation. Despite numerous reasonable requests from the House and this committee, the Attorney General has refused to put the interests of the American people first. He has refused to allow Congress to view the full report and the evidence on which it is based. And now, just this morning, he's pleading the president to assert executive privilege only when the possibility of contempt is on the table. I was elected into office to lower healthcare costs, fix a broken immigration system, pass common sense gun reform laws. But I was also elected to take an oath to defend the Constitution of the United States. I take my job very seriously. And being a mom, I can assure you that I can do more than one thing at a time. In addition to passing legislation for the people, Congress also has a duty to perform our oversight function to make sure that this administration is taking adequate steps to protect our elections from future attacks. And we can't do that job with an administration that obstructs our constitutional responsibility at every single turn. This contempt citation is necessary to ensure that the Attorney General does not violate his oath to uphold the Constitution and is held accountable to Congress and to the American people. I ask my Republican colleagues across the aisle who speak so strongly against the violations of democratic values and freedoms in Venezuela, in Cuba, to not abdicate their Article I powers to this president. Our Constitution, the separation of powers, and our very democracy depend upon us to support and defend the Constitution of the United States and faithfully discharge the duties of our office. I yield the rest of my time.
Mr. Chairman. For what purpose is the gentleman from Georgia seek recognition?
Strike last word.
Gentleman is recognized.
Okay, continuing this out, and I know that I'm going to yield to some of our members as well, but it's not an empty point. And I think this is the concern that has been brought up, because I've said it before in this committee, that we don't vote on intent, we don't vote on what we say, and we don't even vote on our words, we vote on words on paper. A judge, anybody else would vote on what's presented to them in court. And the subpoena that I have before me says that the Honorable William P. Barr, Attorney General, will command to appear and identifies certain things to produce. Those things that he was supposed to produce are, number one, the complete and unredacted version of the report submitted on or about March 22nd, 2019. And it says includes but not limited to summaries and tendencies, all documents referenced in the report, and all documents obtained through that. There's no qualification there. It says you will produce everything that we just said with no qualifications of 6C. And if everything is involved there is 6C information in there. So this is something that when you look at when the court would look at this, and if you even look to the back, article on 15 under, I think it's, report number 15 on definitions, 15 says the report means the complete and unredacted version of the report submitted on or about March 22nd, 2019. We had offered an amendment that said that would have excluded 6C information from this report and from this subpoena. That is not in this subpoena. The four corners of this subpoena simply say, give us the whole report. It doesn't say nothing that's not against the law. And it can't be assumed when you put this in here. So as we look at this is an important point. And also there's been a couple of cases where it says, as in other cases, and some of you, Mr. Chairman, you've said this and others, that as in other cases where we go with the Attorney General to make this happen, there is no other cases. The independent counsel case that you cite and others was done under the independent counsel statute, which the independent counsel went to the court to get the information, not the Attorney General. So as we look at this, it's not Mr. Johnson brings up a very valid point. And when we rejected the 6E amendment to the subpoena, this is now what we are left with a subpoena that truly does, on any valid reading of this, that says, if you read this subpoena, any attorney, any judge, it says, give me the whole report. I don't care, even classified. I mean, it's all, you got to have everything here. So this is just the four-corner document of what a judge would look at when enforcing this subpoena. So it does matter. It's not irrelevant. It is a valid question. If we have rejected an amendment on 6E, how do we go, how else then do you say that it's not, except we take your word for it? And around this place, neither side takes our word for it. You go on what's on the paper. Mr. Biggs. I yield to the gentleman from Arizona.
Thank you, Mr. Collins. I appreciate that. The point I wanted to make is real simple. It's getting back to what's going to happen when the court gets there. The court will look at documents. The court is going to look first at the document which talks about a full and complete unredacted, excuse me, it's going to look at the subpoena which has a full and complete unredacted report. And the point has been made by Mr. Johnson. It's also been made by Mr. Buck and Mr. Collins. That is what will be questioned. Mr. Barr, did you submit to that report, to that subpoena? And there's no way he can comply with the subpoena because we have not qualified it, which puts him back to what I kept saying this morning, is that you've placed him by the terms of the subpoena in an untenable position. It's either be held in contempt or violate the federal law. And so when we move there, the judge is going to say, and since we've now basically qualified the contempt motion that we're here marking up, the judge is going to say, the subpoena you have is now invalid. Your contempt citation is premature. You did not give Mr. Barr an opportunity to respond to the modifications that you made in your contempt hearing. That's what this is about. So when people start talking about rule of law, and we need to do that, and I am all for the rule of law. By modifying today, saying what Mr. Barr has to comply with, you have unalterably changed this subpoena. You're premature on the subpoena that is outstanding. There is no subpoena that's been modified. It is only your motion that has been modified. How in the world will the court rule in favor of you? It's a legalistic argument, but the reality is that's exactly what a judge is going to be asking you. And I yield back to Mr. Collins.
And I think, gentleman from Arizona, again, this goes back to the whole argument we've had on why are we here today. Is it too quick? Have we come to this point too quick? Have we reached an impasse? Today, we've, in essence, and I think it couldn't be construed maybe too broadly here, we've actually made an offer here at this committee today on the contempt hearing. So with that, I yield back. Thank you, Mr. Chairman.
For what purpose does the gentleman from Colorado rise?
Move to strike the last word.
Gentleman is recognized.
Mr. Chair, I'm happy to recognize you for a moment if you'd like to respond to the ranking member.
Let me just, I thank the gentleman for yielding. I just want to say the following. We've been beating a dead horse. We've made clear, two comments. The Constitution requires that the two branches of government engage in an accommodations process when one wants information from the other. I asked the department to begin that dialogue with us long before the report was released, in anticipation of our needs, long before the Mueller report was released. I issued a subpoena only when the Attorney General made clear that he would not provide it to us in any meaningful way. I asked to negotiate with the department at least 5 times over 6 weeks. They provided us with nothing. When we moved to contempt only after the AG blew through our May 1st deadline, I am still willing to reach an accommodation. Late last night, we were still negotiating when the department pulled the plug and declared its intent to declare privilege over all of the material that we wanted, over all the material from the grand jury material, both the grand jury material and other redactions, and all of the underlying evidence. And yes, absent an accommodation, the Attorney General must comply with the lawful subpoena. That is the general thing. Yeah, I heard that with Holder, they negotiated for 400, it took 400 days, but the Holder supplied many documents throughout that period. In the end, there was an impasse. Here, they refused to negotiate with us or to deal with us in any way or to give us a single piece of paper. Secondly, we keep talking about the 6E material. We've made clear that the 6E material is not included for purposes of the subpoena. And if that wasn't clear enough, when we accepted Mr. Gates's amendment, that is made super clear. Now, we hope to continue negotiations anyway, but you're beating a dead horse. That is not relevant because A, no one's going to insist on it, and B, the amendment to the contempt motion makes that very clear. I think the gentleman, I yield back. I give time back to Mr. Neguse.
Would the gentleman yield?
Thank you, Mr.
It's
Chair.
his time.
I know, and that's what I was asking. Will the gentleman from Colorado
I'll
yield?
yield for a moment to the ranking member.
Okay, thank you. Again, I get it. If they were wanting to discuss this, it's not happening. But there's no, I mean, how many lawyers walk into a court today and present a 4-corner document to a judge, and then you try to argue, well, that's not what we meant, Your Honor. I meant to actually exclude this, but I didn't have it. I've lost cases that way because I didn't put what I wanted in there. We can't say it doesn't matter. So I appreciate the gentleman yielding here just to make that clarification. It does matter what's in the subpoena. It does matter. And my question is really from a legal perspective, by adding this to contempt today, did we in essence, did the majority of us make an offer to the Department of Justice? I yield back to the gentleman. Thank you.
Thank you. Mr. Chair, I just, again, want to, as I imagine we're getting fairly close to the end of this hearing, kind of circle back to why we're here. And I think Representative Escobar, the gentlewoman from Texas, as well as Representative Musgrove-Powell, did an articulate job of doing precisely that, which is to say that fundamentally, our democracy was attacked by a foreign adversary in 2016. And the Mueller report makes abundantly clear that that was the case. I'll refer the American public to page 3 of the contempt report. And I'll quote, "The redacted Mueller report contains numerous findings, including that the Russian government attacked the 2016 U.S. presidential election in sweeping and systematic fashion through a social media campaign and releasing hacked documents, and 2, that Russian intelligence services intentionally focused on state and local databases of registered voters and state and local websites affiliated with voter registration. For example, quote, the GRU compromised the computer network of the Illinois State Board of Elections, then gained access to a database containing information on millions, on millions of registered Illinois voters and extracted data related to thousands of U.S. voters before the malicious activity was identified." Here's the point. If I can leave the American people with one thing, it is this. If we don't take actions to prevent it, it will happen again. And that is why it's so fundamentally important for us to be able to discharge our constitutional duties by reviewing the Mueller report and the underlying evidence. And by the way, this is why I'm particularly frustrated today, because This is not an unreasonable request. As I referenced earlier in this hearing, I'll read a letter, April 25th, to the Attorney General of the United States that says, I'll quote, "In our prior letter, we made clear that for the committee to discharge its unique constitutional and statutory responsibilities, the committee requires full visibility into the special counsel's office's unredacted report, findings, and underlying evidence and information." That letter is signed by Congressman Adam Schiff and Congressman Devin Nunes of the Intelligence Committee. I am at a loss for understanding why my colleagues on the other side of the aisle, who I respect greatly, would not join in our efforts to be able to ensure that this committee and its distinguished members have access to the special counsel's report so that we can ultimately do our jobs. And given the Attorney General's unwillingness to allow us to do so, and this administration's engaging in wholesale obstruction of Congress to be able to engage in its oversight duties, we have no choice but to move forward with a contempt citation. And that's why I'll be voting no on my colleague's amendment, and we'll be voting yes in favor of the citation. And with that, I yield.
For what purpose does the gentleman from Pennsylvania seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I yield the balance of my time to my colleague from Louisiana.
I thank the gentleman for yielding. Mr. Chairman, I just want to make sure that we get something straight for the record, because if there is a court proceeding about this, this will be very relevant to the trier of fact, to the judge in that matter. You said in your own words, I think, just a few moments ago in response to my inquiry, that the subpoena that you issued, that this committee issued to the Attorney General, is just the next step in a dialogue. We're here on an extraordinary contempt citation. This is not a game. Your subpoena is issued to the Attorney General of the United States of America, and it reads in its first line, "You are hereby commanded." That is not an invitation to a dialogue unless we're going to construe it that way. And if that is the view of the chair, we need to make it crystal clear for the record right now so we can dispense of the court hearing that many of us anticipate to come out of this. This record will make that court hearing moot and unnecessary. This is a dialogue and not intended by the sender of the subpoena to be an actual subpoena, apparently. Look, the authority that we have in the Congress to issue subpoenas is a heavy one. We should not weaponize this. We can't be using this stuff for political purposes, and that's what's happening in this committee right now. Many of the legal rights usually associated with a judicial subpoena don't apply to a congressional subpoena. We have a huge weight of authority, and I just feel like it's being abused here. And I think the admission that you made just a few moments ago is extraordinary. It makes much of what we've done here today a total waste of the American taxpayers' time. And I'll yield back.
Mr. Chairman. For what purpose does the gentleman from...
Mr. Chairman.
Oh, I'm sorry. Mr. Reschenfeller has the time.
Mr. Chairman, I yield the balance of my time to my colleague, Mr. Biggs.
Thank you. Thank you. I just want to make two quick points that I think have to be said. When I listen to some of my colleagues on the other side, and they talk about the Russian meddling, which is one of the findings in the Mueller report, there's nobody on this side of the aisle that is minimizing that. And there's no one over here that doesn't think something has to be done. In fact, it was the Obama administration under which that took place. That's when that took place. But we need to, both sides are culpable. Both sides need to fix that. But it has nothing to do with whether Mr. Barr has complied with the subpoena. That's why we're here, to see if he should be held in contempt. The subpoena in and of itself, as we've now discovered, was apparently the words within the subpoena were not what was intended by this party, by the chairman. That is a problem when you're going to find someone in contempt. Contempt says there was a specific order of performance to be made. You didn't make it. We're going to hold you in contempt. That has nothing to do with whether we all think something should be done about Russian interference in the most sacred right of being in a democratic republic, which is voting. But what it does have to do with is whether we follow the rule of law. And what I'm seeing today is we will issue a subpoena, but when it comes time to enforce the subpoena through something called a contempt citation, we will start modifying what we really intended. That cannot stand, and with that, I'll yield my time to the gentleman from Colorado.
I thank the gentleman for yielding, and I just wanted to respond to my friend from Colorado. Rather than doing this on the plane ride back on Friday, we could do it right here in public. I don't think anybody on this side of the aisle disagrees that the Russians meddled, interfered, tried to influence the outcome of our election. And if this is what this is about, I'm absolutely in favor of proceeding and finding out more information and doing our job as oversight. A number of the folks on this side of the aisle were very adamant about our Article I powers when President Obama was in office, and a number of them are very adamant right now about our powers of oversight and take this very seriously. The issue before us is whether the president colluded, conspired with the Russians, and it's clear from the Mueller report that he did not. And so I think we need to move on and not attack the Attorney General in this way. I understand from the chairman that we are not after 6E material until we get an order from the court, that we are willing to only look at classified material in a secured setting. I think both of those things make a lot of sense. Then the other two categories of documents I really don't know enough about. I can't support the underlying motion in this case because I just don't know what the negotiations were, and I think this is premature.
Gentleman's time has expired. For what purposes, the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I've been amused over the last half hour or so listening to the sweet talk coming from the other side of the aisle. It reminds me of when I was courting my wife and trying to get her to agree to marry me, and I just wouldn't let her leave until she committed. And I just kept talking and talking and bringing up 6E and 6G and everything that I could. And so finally, 39 years ago, she agreed to marry me. So I won. But we can't let the Republicans win today trying to sweet talk us and trying to sweet talk the American people. The issue is not about 6E. Don't get it twisted. The issue is about whether or not the Republicans on this panel will be consistent with the vote that they took on the floor of the House on March 14th. And they voted unanimously in a rare form of bipartisan unity. We all voted 420 to 0 for a full release of the full Mueller report. What happened to change their minds about it? Because now they're trying to sweet talk us into not getting the report. What changed? I believe what happened was on April 22nd, my colleague from Georgia was able to go and view the unredacted report. He went by himself and he agreed that he wouldn't say anything to anybody about it, but now we have the Republicans in lockstep, all of them agreeing to obstruct our ability to get the report. They have rescinded their support of March the 14th, and I wonder why. Is it because
the gentleman
they
yield,
understand? Is it because they have seen the full report and now they don't want us to see the report because they are afraid that it implicates the president? What is the reason why they have changed their minds from March 14th to today? And with that, I will yield to the gentleman from Colorado. I would like to have an answer to that question. It's more than a rhetorical one.
Yes,
and
sir.
we'll give
the gentleman yield?
Sir, I appreciate the gentleman from Georgia yielding. I will just be brief, not to belabor the point with respect to 6E, but I do think this is an important clarification. The amendment that we adopted from Mr. Gates states simply, no provision in this resolution or report shall be construed as a directive for the Attorney General to violate federal law or rules, including but not limited to Rule 6 of the Federal Rule of Criminal Procedure. The Attorney General, there are a variety of ways in which he could have complied with this subpoena and complied with Rule 6. One of the ways, as has been discussed during this hearing, was to simply tell this committee that he believed that he could not produce the grand jury materials, but that he would join us in a request at a court of law to ultimately produce those materials. I will also say the members of the Intelligence Committee make a compelling case that there is another exception under Rule 6E that very well could apply. If you look to footnote 3 in their letter to the Attorney General, where they state, To the extent any such information relates to grand jury matters, Rule 6E of the Federal Rules of Criminal Procedure impose no bar to the disclosure of such materials to this committee under the exception set forth in Rule 6E, subparagraph 3, subparagraph D, which I'm new to Congress, but many of you were here when the amendments to Rule 6E were made in 2001. All right, and this relates specifically to information involving foreign intelligence, counterintelligence, grand jury matters involving grave hostile acts of a foreign power, and so forth. So the point being that there are a variety of different ways in which the rule can be complied with and the subpoena could be complied with. In this case, the Attorney General clearly, after much negotiation by the chairman of this committee, who showed great patience throughout this entire process, chose not to do so. With that, I yield back to the gentleman from Georgia.
Thank you, and I yield to the gentleman from New York.
Thank the gentleman from yielding. I fully agree with the gentleman from Colorado, obviously, but I want to say that we're making a big mountain out of a small part of this. And remember, the main thing we're talking about is not Rule 6E. The main thing we're talking about is the absolute stonewalling by the Justice Department, the Attorney General, and the President, not only of the unredacted Mueller report and the underlying evidence, but of everything. The President has said we will reject all House subpoenas. What we are dealing with here, and we should not lose sight of the main fact, is one, a total stonewalling of Congress from all oversight activity, which is unprecedented in the history of the country, and two, the refusal to let the Congress see the Mueller report, the unredacted Mueller report, and the underlying evidence. And I would point out that the comparisons made to 20 years ago are completely off base, because 20 years ago, the entire Starr report, 445 pages and 17 boxes of documents were handed to the Judiciary Committee, and we saw all of it. And the debate was whether how much of that or all of it should be made public or not. Public. No one is urging that the redacted portions of the Mueller report and the underlying evidence all be made public. Obviously, there are parts that cannot be made public, but obviously the Judiciary Committee should make that decision, not the Attorney General of the United States, who has misled the public, deliberately misled the public, and apparently misled the Congress as to the contents of the report, and has obviously a motive other than that, a motive to protect the President. He shouldn't make that decision. The Judiciary Committee should make that decision, as has been the case in every previous case. That's what's at stake today. I yield back.
Mr. Chairman. Mr. Chairman. Mr. Chairman, down here. Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Who strike the last word?
Gentleman is recognized.
Thank you, Mr. Chairman. Before yielding a ranking member, I just want to say a couple of things. First of all, most of us, as well as being on this committee or on other committees, I happen to be on the Foreign Affairs Committee, and we've looked over the years very closely at some of the abuses of the Russians, Putin in particular, all across the globe and in his own country as well. For example, killing his political opponents, literally, usually through other people, but it happened. Jailing reporters, basically suppressing any true form of democracy in Russia. In other parts of the world, we saw what he did in Ukraine, basically using his so-called little green men to take over Crimea, and then to brutally attack the people of eastern Ukraine, shooting down a civilian airliner, basically propping up Bashar Assad and bombing innocent civilians, being responsible for killing thousands and thousands of innocents. So it's not a surprise that in the Mueller report we saw that there's confirmation that he was trying to affect us here, in the probably the most significant democracy on the globe, trying to adversely impact our elections as well. We saw him do it in other parts of the world as well. Not surprising he was doing it here. But again, I just want to mention, and the gentleman from Arizona said this, and others have as well, that this happened not when Donald Trump was president. This happened under President Obama's watch. That's when it happened. And basically a blind eye was turned on most of those occasions. We saw, the famous red line in Syria where action was promised and didn't happen. And investigations were talked about. It was talked about doing something about the Russians, but ultimately, nothing was done by the Obama administration to stop this. And a lot of times we wonder why. I think perhaps it's because most people expected Hillary to win the election, and I don't think he wanted to think that there was Russian hanky-panky involved in her winning. But that didn't happen. Donald Trump won, and so therefore it became a huge issue. But let's not ever forget that this happened under President Obama's watch. That's where action didn't take place. And if you want to study and go into dealing with the Russians and stopping them from doing this type of stuff, that ought to be bipartisan. We'll work with you on that. But this is nothing but politics. This is about the next election. This is about trying to demonize the Attorney General. That's what this is all about. The Mueller report didn't come out the way you thought it was going to come out. You're really disappointed about that. And now you're fearful that this Attorney General is actually going to look in to what the Mueller report should have been about. And that was about trying to influence an election, trying to tip an election into one party's favor over the other. That's what is going to be looked into now. And I think a lot of my colleagues don't like that. I'd like to yield my additional time to the ranking member.
Thank you. I appreciate that. And look, real quick, and I'm glad my friend from Georgia, who we've talked about many things, he is a sweet talker, and I'm glad his wife actually agreed. The problem is we're not sweet talking here. We're talking about a subpoena to the Attorney General. This is not sweet talking. This isn't a subpoena to the Attorney General. And we have been consistent. And how we know I've been consistent? Because I sat on the floor and actually debated this resolution. And the resolution says, except to all this will be released except to the extent in which public disclosure of any portion thereof is expressly prohibited by law. Nothing changed. There's no backing up here. Don't fool the American people. Don't try to tell them that something changed. Nothing changed in that process because you can read the resolution. The resolution says basically what we didn't say in the subpoena. The subpoena says you want everything. This actually said no 6C, no classified that you can't get. That's what the resolution said. There's been no backup there at all. And the main thing that the chairman just said is something here in the Intel Committee. I want to address this. The Intel Committee is not on this subpoena. So it doesn't matter. I don't care what the Intel Committee says. The Intel Committee is not on the subpoena that was issued by this chairman in this committee. And on the point in the face of this document, it asks for all things. The main thing is not about dialogue. The main thing is not about underlying documents. The main thing is what does the subpoena ask for, and the subpoena asks for everything. One last question before the time runs out. And Mr. Chairman, you have cited on several occasions now discussing this, many cases where this has actually happened. Where we've had many cases outside the independent counsel statute. Please cite me cases in where this has happened, where the Attorney General goes with the committee to actually go and get this done. Outside independent counsel, which independent counsel actually said you're supposed to do this, outside of that, what are the cases? Outside of independent counsel, you stated on several occasions from the dais this morning and this afternoon that previous cases, this is the way we've always done it in previous cases. Our side can't find a previous case outside the independent counsel statute, outside the independent counsel, or a
Is the gentleman asking me a question?
proceeding. Yes,
The gentleman yield?
I yield.
Well, for example, Watergate, Whitewater, the Clinton Gore campaign finance case, Iran-Contra, the impeachment of Judge Hastings,
Reclaiming
the
my
Mike
time.
Espy matter, for example.
Reclaiming my time. You just answered everything that I told you it was not. And that was, I said outside independent counsel or impeachment, which we had. I'll allow that I didn't say impeachment.
Those are not impeachment inquiries.
Again, the problem comes in here. My time has expired and we need to, somebody else can take the time, but this is a problem. The subpoena doesn't say that.
I would remind the gentleman, and everybody for that matter, that what we were debating supposedly is an amendment over my alleged change of position 20 years ago and nothing else, but we seem to have gotten afar from that. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
The gentlelady is recognized.
Mr. Chairman, I have to report to you that I, over the course of the last 30 minutes, am slightly encouraged. I heard at least 2, maybe 3 of the minority members of this committee say they were upset about Mueller's finding of the sweeping and systematic interference in our election by Russia. I am encouraged. I have to admit, over the course of many months now, I have not heard Republicans say that. I hope that they share our outrage. I hope that they share our wish and will to protect our system of government and our elections. So it would follow, it seems to me, that they would also be outraged that what happened during that sweeping and systematic interference with our elections was hundreds of meetings with Trump and Trump associates, hundreds of contacts. That might have been during the Obama administration, but it was during the Trump campaign. I hope you share my outrage at that. The campaign welcomed, wallowed, invited publicly that interference by a foreign foe. And so it would also follow that the minority members would be outraged by what the Mueller report found in Volume 2, which, as hundreds of federal prosecutors have now signed onto a letter this week, says, each of us believes that the conduct of President Trump described in the special counsel Mueller's report would, in the case of any other person, result in multiple felony charges for obstruction of justice. Where's your outrage on that? That the president's effort to try to fire Mueller over and over and then falsify his efforts to do that? The president's efforts to limit the scope of Mueller's investigation so as not to investigate him. There's outrage to be had, and so it would follow. I'll conclude before yielding the balance of my time with where you took us last week, Mr. Chairman. You asked an important question. History is watching. Our children are watching. Our voters, our constituents, Americans are watching. Where will you be counted? Will you be on the side of obstruction? Will you be on the side of an administration that simply wants to darken the entire Mueller report, try to reclaim privilege that they've already waived? Where will you be? Will you sit silently? Will you argue on behalf of a president who has falsified everything, who cares nothing about the truth, who cares nothing about our system of government? Will you sit silently, or will you boost him up in his false claims? Or will you stand up for the rule of law? Will you stand up for the Constitution? History will judge us. And with that, I yield to the gentlewoman from Texas.
Thank you so much, Ms. Dean. I, like you, am delighted. It only took 6 hours into this hearing for us to finally get to what this is about. And this is about Russia's attacks on the United States of America. And so how, knowing, again, restating something I stated earlier, knowing they are still at it, knowing that they were so wildly successful, how do we prevent that? Who did it? Who aided and abetted? Who hid the truth? We've seen much of that in the Mueller report. We have not seen it all. And the reason that we need to see it all, and the reason, more importantly, that the American public needs to see it all, is so that we ensure it never happens again. So unless you are willing for it to happen again, I would hope that our colleagues on the other side of the aisle would join us and would actually be demanding with us to see everything. Let's see it all so that we can then hold those accountable who should be held accountable, and more importantly, prevent this from ever happening again. That is well within our power. It's this committee's obligation and responsibility, and we invite our colleagues to join us in that quest for the full truth. Ms. Dean, I yield back.
Ms. Dean, would the gentlelady yield? Behind you.
I will yield. Thank you.
I thank Ms. Dean and Ms. Escobar. Their point, I believe, is who cares if it was President Obama who was the president when we were attacked? I don't understand that point at all. It was still the Russians attacking us. It's almost as if you're suggesting that we were asking for it because he didn't do enough to counter it, and now we should have to live with what they've done. I have spoken up against the response. I believe it was inadequate. I think Donald Trump was in their head when he said that the election was going to be rigged, and so they didn't want to counter that and reinforce that claim by Donald Trump. The response should have been stronger, but we were all attacked. That's the point here. It doesn't matter who the president was. The Russians attacked us. You should be uniting with us to stop that. I yield back.
On the amendment, all in favor of the amendment will say aye. Aye. Opposed, no. No. The noes have it. The amendment is not agreed to. If there are no other amendments, we can...
I have an amendment.
The gentleman from North Dakota is recognized. For what purpose does the gentleman from North Dakota seek recognition?
Mr. Chairman, I have an amendment at the desk.
Gentleman has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Armstrong of North Dakota.
The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. We've done a lot of this today, and there's a lot going back and forth, but let's remember what this hearing is about today. This hearing about today is about holding the Attorney General in contempt for violating a subpoena that he would have had to violate the law to comply with. We can talk about speeches, and we can talk about interference, and we can talk about, we didn't really mean that he had to provide grand jury testimony, but we've spent the last hour and a half looking through any comments that have been made on news or in print or anything since this entire thing came up, and you know what's interesting? Not a single person has said we don't really want grand jury testimony. It is the full unredacted Mueller report. That's what the subpoena says. That's what the narrative is. So to have this reasonable dialogue after we've already committed to a contempt proceeding seems to be a little, if we're using phrases, I'll just use cart before the horse, different types of issues. What we did find, though, was the chairman on CNN stating that every other AG has gone to court. And outside of, I think, the ranking member making sure that's a misleading statement, it's a political argument and not an adequate reflection of the current status of the law. So let's make sure we at least understand what the current status of the law regarding release of grand jury testimony is. There is no federal code compelling the AG to go to court voluntarily to release grand jury testimony. The AG has the sole responsibility and prerogative to determine what DOJ's position will be on the release of grand jury testimony. There is no law that allows a congressional subpoena to compel the AG to go to federal court to release grand jury testimony. The chairman and the majority may want him to release that information. They may think they're entitled to that information, but they have by issuing a subpoena, you cannot force the Attorney General to release that or to go to court to release the information. And so we're offering the amendment, which is, and we have cited several different cases and have brought up for various different reasons. One of them is the Holderson case, Jaworski case. These are cases regarding impeachment with President Nixon. But one of the things we haven't done yet is talked about a case that was decided a week ago. And I think this is probably the most importantly thing that has been missed in this hearing is there seems to be a failure to recognize that there is no guarantee that the court would require the release of this information. And Wheeler v. Barr, which was decided last month in the same DC circuit that we continue to cite from 1972, held that Rule 6E makes it quite clear that disclosures of matters occurring before the grand jury is the exception and not the rule, and sets forth in precise terms to whom, under what circumstances, or what conditions of grand jury information may be disclosed. Rule 6E restricts that persons bound by grand jury secrecy must not make any disclosures about grand jury matters unless these rules provide otherwise. The only rule to provide otherwise is Rule 6E3. So let's be clear about what we're doing. This isn't a fight between Congress and the executive branch. This is the fight between the Democratic leadership, the president, and their base. They know the American people don't want an impeachment proceeding. And if they want to continue down this rabbit hole and continue to have this type of showmanship, then let's at least be clear about what the status of the law is. And with that, I yield back.
Mr. Chairman, point of parliamentary inquiry. Mr. Chairman, point of parliamentary inquiry.
The gentleman will state his inquiry.
My inquiry, is it appropriate or is the committee permitted to vote on an amendment which, as far as I can tell, offers a legal opinion but doesn't modify the contents of the contempt resolution? It's
not a proper parliamentary inquiry.
Okay.
Does the gentleman yield back?
Yeah, I yield back.
Okay, I will recognize myself for 5 minutes in opposition to the amendment. The amendment does two things. It says that my correspondence does not identify any legal basis to compel the department to request does not identify any legal basis to compel the department to request the federal court order to share 6E material. Quite correct. It doesn't identify any legal basis to compel the department because we don't ask that the department be compelled to request a federal court order. It has nothing to do with anything. It's completely irrelevant. The second part says that the correspondence does not account for the recent D.C. court decision in McKeever versus Barr, which holds that a federal court does not possess inherent authority to release grand jury information protected under Rule 6E. The McKeever decision does say that, but it also recognizes various exceptions to enable federal courts to release 6E information, including for judicial proceedings. There is authority that certain congressional proceedings are the equivalent of judicial proceedings. We think that's an adequate legal basis. Beyond that,
they're impeachment.
Beyond that, we've debated this amendment extensively in the last amendment, which is basically exactly the same subject matter. So I urge my colleagues to not waste to oppose this amendment because it is not accurate as to the correspondence, number one. It is not accurate as to the law, number two, and it is completely unnecessary and misleading, number three. I yield back. We'll take a vote on the amendment then. The question occurs on the amendment. Who seeks recognition? For what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
I yield to the gentleman from North Dakota.
Thank you. And just briefly, because I know it's been a long day, but the Attorney General thought it was relevant, which is why it was issued into a response to the chairman. So with that, I yield back to my friend.
I'll yield back, Mr. Chairman.
The question. For what purpose does the gentleman from Louisiana seek recognition?
Move strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to make a simple point. We have been here a long day. There's been some extraordinary admissions, I would submit, by the chair and those who have issued the subpoena. But I just want to quote one more time, one line from the letter that the Department of Justice Assistant Attorney General Stephen Boyd sent to you this morning. It begins, "We are disappointed that you have rejected the Department of Justice request to delay the vote of the committee on this contempt filing this morning. You've terminated our ongoing negotiations and abandoned the accommodation process." And this is the important phrase. "As we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law." Some of our Democrat colleagues have conceded, I think, over the course of the last hour, that this 6E material, that there are ways to get around this, that in its current form and on its face, maybe the subpoena says one thing, but it really means another, and the chairman says, oh, this is just part of an ongoing dialogue. This entire charade today was premature and unwarranted. Our Democrat colleagues have effectively acknowledged that on the record. I think this amendment is one we should support because I think it is not a legal opinion, as Mr. Cicilline said. This is a statement of facts. The facts, the important facts that have transpired over the last couple of weeks in this good faith negotiation by an attorney general that has been completely transparent and who is limited only by the written rule of law. He is trying to comply with that. Mr. Nagu said a few moments ago that, look, there are ways to comply, you can get around this and work with the subpoena. That's exactly what the attorney general has been trying to negotiate in good faith. And yet we jumped the gun. We came in here, we've wasted an entire day when all these important issues are pending before the country, tying up the hands and the time of how many members are on the committee? 40 members of Congress are tied up into this. And it's only, as the chairman says at the end of the day, I just repeat it because it's so extraordinary that he admitted this in this rare moment of candor. Hey, this is really just the next step in an ongoing dialogue. We could have continued that dialogue without this charade. I'll yield back.
For what purpose does the gentleman from Georgia seek recognition?
I'll move to strike the last word.
Gentleman is recognized.
Mr. Chairman, all this sweet talk is just killing me. I know how my wife must have felt. And I'm so sorry. I'm going to go home and get on one knee and apologize to her for putting her through what we're being put through today. The stakes are too high, however, for us to yield to the sweet talk. Will darkness, secrecy, and obstruction prevail, or will truth and the rule of justice overcome the sweet talk? That is the question that we are here to answer today, whether or not we're going to issue this subpoena to obtain this information that the American people want and that the members of the House Judiciary Committee need in order to do our work. And with that, I'll yield to the gentleman from New York.
Thank the gentleman from yielding. I want to point out again that the amendment in front of us does two things. It points out that the language that my correspondence doesn't provide a legal basis to do something which we are not asking be done. That is to compel the department to request the federal court to share material. We've asked them to do it, but we do not seek to compel them to do it. And it doesn't take account of the decision in the McKeever case, which, however, does not bar a court from ordering the grand jury material, the 6E material, delivered to the committee under various conditions which we think we can meet. So it's totally irrelevant. More to the point, it is very hard to credit the good faith, so-called, of the Attorney General when for 6 weeks, starting on when he first misstated what was in the Barr report, in the Mueller report, misled the people, then for 6 weeks refused to talk to us, refused to negotiate with us at all about getting access to the unredacted report and the underlying material, only evinced a willingness to negotiate with us for that purpose when we threatened this contempt in the last week, waited till the last day, basically, to make an offer, made a ridiculous offer that only, a couple of days earlier, made a ridiculous offer that only the chairman and the ranking member could see the material and then couldn't tell anybody about it, anybody on the committee or in Congress, so it was useless. Rejected our counteroffer, which said that members of the committee should have access to this material. And I would remind you that in all previous cases, members of the committee have had access to material. The question was whether the public should have access to it, not the committee members. And that was a decision for the committee and for the Congress. And we didn't break off negotiations. They broke off negotiations when we said we would go ahead with the contempt proceeding last night if they didn't make us a better offer. And they rejected our counteroffer. They didn't make us an offer other than 2 people can see it, 1 extra staff person. That was their counteroffer, but 2 members, and couldn't discuss it with other people. That was an insulting offer. They broke off negotiations. It leaves us no choice but to vote a contempt in order to enforce the right of the committee and the Congress and ultimately the American people to see this material, which very much implicates the president's campaign working with the Russians to subvert an American election, very much implicates the president in obstruction of justice. The special prosecutor said he didn't charge that basically because of the Office of Legal Counsel policy that you can't indict a sitting president for anything, no matter how much evidence there is. And we need to see, on behalf of the American people, all the material here and material that may be exculpatory, as people have pointed out, so that we can conduct a proper oversight in this matter. So I urge my opponents to oppose the amendment, but to keep in sight what's really at stake here. What's really at stake is the ability of Congress to do its job to protect the American people. I yield back.
Thank you. And Mr. Chairman, again, something bad must have happened from March the 14th when every Republican, along with every Democrat, voted for the release of the full Mueller report. And then March 22nd, when the ranking member goes to see, under a gag order, by the way, goes and sees the full report, and now everybody on that side doesn't want to release the report.
Will the gentleman yield? I can answer your question.
It doesn't pass the smell test, and yes, I yield.
The answer is very simple. We voted unanimously to release the report within the bounds of the law. That's what the Attorney General's doing, and that's what apparently you keep missing. I don't understand why that's so difficult.
The sweet talk The sweet talk is obscuring the real issue, and we need to stop the sweet talk and get to business of voting on this resolution here. And I'd hope that all of my friends and colleagues on the other side would join us in preserving and protecting the rule of law. Thank you.
Thank you. I ask unanimous consent to enter into the record this timeline of negotiations with the DOJ beginning March 25th, and all the letters referenced in the from me to the department and in the other direction from the department to me, referenced in this timeline. Without objection, this material will be. You object?
Can I see it?
It's been attached to our press release.
Are we going to get? What now? Okay. And is this from you, or is this put together by the staff? As far, I mean, yeah, okay, by yourself. Okay, because again, part of this timeline, and we offer the timeline on the public negotiations, but we have no knowledge of maybe something that I haven't had a chance to read.
Well,
And we've asked, and we're just asking.
This references, I believe, and you'll correct me if I'm wrong, this references only letters written by the department to us. And
I just want, I didn't, it's fine, it's public, we're fine.
Without objection, then, this material will be entered into the record. For what purpose does the gentleman from Texas seek recognition?
I'm rising in support of the amendment.
Does the gentleman seek to strike the last word?
Yes.
Last word is duly struck, and the gentleman is recognized.
Thank you, Mr. Chairman. I agree with the chairman that it seems ridiculous that we have to go into SCIFs to review material that is classified, secret, privileged in some way, and not suitable for public release. We're not allowed to take our cell phones in. We have to leave those outside the room. We're not allowed to take notes, but if we do take notes, or in some cases are allowed, we have to leave the notes there in the room. We can't take them with us. We can't discuss anything anywhere outside the SCIF that we saw, heard, or read in the SCIF. And the chairman said, the Attorney General, in essence, said we could review the much more unredacted report in a SCIF, but we couldn't tell anyone. It sounds ridiculous, except those are the rules of the House for reviewing material that is not subject to public review. So it would sound ridiculous, except they're the rules. We have to follow the rules. We get into trouble when we don't follow the rules. Again, we're back to where we're going to ultimately vote. You have the votes to hold Attorney General Barr in contempt of Congress, which will be meaningless because you will never be able to enforce such a vote of contempt before a court of proper jurisdiction, because you cannot legally, before a court, have someone in contempt for refusing to do what the law says they cannot do. So, and that admission is what we got when the majority offered, oh, here's a negotiation. You agree to go into court with us to get a court order saying you can release the grand jury material. That is an admission of fact, an admission of law that the Attorney General cannot do what he's going to be voted apparently in contempt for failing to do. I applaud finally having an Attorney General that believes in following the law. And let me say, I totally understand the skepticism of the majority when anything is redacted, because we found out during the Obama years so often, and probably a majority of the time, when anything was redacted, it was making the administration look bad. It wasn't because there was something that was truly classified. So I can understand, having seen that out of the Obama administration, you might want to project that onto this administration. But what was clear about Attorney General Barr, frankly, I didn't know him. I didn't know if he'd be a decent Attorney General or not. But I've been impressed. He's trying to follow the law. He's trying to get to the bottom of things. And if this were Eric Holder or Loretta Lynch, then I don't have any doubt they would not have let you have any of the report if it pertained to their administration. So I thought the Attorney General bent over backwards to present what he did, and now he's going to be met with a vote of contempt. I guess this is the rule. No good deed goes unpunished. Attorney General Barr, maybe by a vote of contempt today by this committee, will learn the lesson that my late mama used to just say, there's some folks you just can't help. And with that, I will yield back.
Gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
I have a lot of good friends, Mr. Chairman, including yourself, a lot of good friends on the other side of the aisle. And I'm simply trying to clarify the consistency of the false narrative that has continued as a theme of my friends on the other side of the aisle. Chairman Nadler has been consistent, and we've been consistent. We've had three elements to our request. It has been modified to the extent of the two committees, Republicans and Democrats, of the Intelligence and Judiciary Committee, specific documents that we could specify, and 6E materials is a part of it, operable under the law, either the Attorney General and DOJ walking into court with us saying what can be released, or not opposing when we go into court to get a court order. The false narrative that the whole premise is on trying to get grand jury materials, and I'm sure the redundancy of this has strained the imagination of the American people. What is 6E? It only means that documents used in a grand jury, like you'd be down in your own backyard and you had a grand jury for a criminal case, those materials are typically not seen. In this instance, because of the need for the thorough investigation on behalf of the American people, we would use the courts. I want to move away from that. That is not the anchor of what we have requested. And then you cannot ignore the series of meetings and engagements that the staff has had. But what occurred in the last 24 hours was a Saturday night massacre of rejection. The DOJ stopped in its tracks of working with us. Can we understand that? They stopped in their tracks of working with us. And early in the morning, we received two letters dated May 8th simultaneously. There was no space to be able to engage in a discussion if you receive a letter of disappointment saying that we are not moving forward anymore. You have terminated our ongoing discussions and abandoned the accommodation. We're still engaged. Again, a Saturday night massacre of rejection. Simultaneously comes the letter that says we're going to ask for a blanket executive privilege on everything. What more do you think people who are fact finders can do? If our negotiating partner has turned the lights out and implemented Saturday night massacre with letters rejecting our honest attempt to negotiate. Then they want to use the words of Mr. Nadler. I'm glad that he is a gentleman that says that he has a right to change his mind, or he's been edified and he's always enlightened, and so he's gotten the light and seen the light, or has a different interpretation. That's just and fair. We say it in the open. But we have a colleague, Chairman Cummings, who's not here to defend himself. And so he was used to say that he's against subpoenas, and he said it 7 years ago. So let me just add into the record the words of the chairman of the Government Oversight Committee, Mr. Elijah Cummings. At the time of the Republican contempt vote 7 years ago, Attorney General Holder had already produced more than 7,000 pages of documents to our committee. To my knowledge, Attorney General Barr has refused to turn over any document. He went on to say the night before the contempt vote in 2012, and I remember this well, Attorney General Holder was really trying not to get a contempt vote. He found this particularly sensitive for his integrity, so he was working with the committee. Attorney General Holder personally came to meet with Chairman Issa and me and offered to provide copies of additional internal deliberative documents. Here, Attorney General Barr is blocking the production of the very documents that General Holder came forward to produce. He was like that in the Judiciary Committee as well. Then Attorney General Holder made a fair and reasonable offer to resolve the impasse after providing thousands of pages of documents and numerous interviews. Here, Attorney General Barr refused to even show up. So in 2012, Ranking Member Cummings did ask for a short delay to allow the committee to consider an 8-page legal document asserting executive privilege and an offer from General Holder to produce additional deliberative internal documents. Let us not establish a false narrative. There's apples and oranges from what happened in 2012. I would say to my colleagues, join us in this recognition that to do our job, we need the documents. Work with General Barr. If you cannot do that, then vote for the contempt citation. With that, I yield back my time.
The question is on the amendment. Those in favor say aye. Opposed, no. In the opinion of the chair, the nays have it, and the amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question occurs on the amendment in the nature of a substitute as amended. I'll take the vote in a moment, but I will remind members that after the vote on the amendment in the nature of a substitute, there'll be a vote on final passage. All those in favor of the amendment in the nature of a substitute as amended, respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the committee report for a resolution recommending that the House of Representatives find William P. Barr, Attorney General of the United States Department of Justice, in contempt for refusal to comply with a subpoena duly issued by the Committee on the Judiciary as amended, favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
And the ayes have it.
Roll call,
Committee
Mr.
report.
Chairman.
The roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell?
Aye.
Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins?
No.
Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? No. Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stube? Mr. Stube votes no.
Has everyone who wishes to be recorded been recorded? Has the gentleman from Tennessee been recorded? Does the gentleman from Tennessee wish to be recorded? How does the gentleman from Tennessee wish to be recorded?
Mr. Cohen votes aye.
We have two more people coming.
Mr. Chairman.
In the middle of a roll call.
Mr. Chairman.
Gentleman from Georgia.
After all the eloquent speech today and we're talking, I forgot, am I recorded?
Mr. Collins, you're recorded as no.
Thank you. I'll consider it be a no.
Madam Clerk, how am I recorded?
Mr. Nadler, you're recorded as aye.
I wish to be recorded as aye.
Chairman,
The gentlelady from Texas.
how am I recorded?
Ms. Jackson Lee, you are recorded as aye.
I think that's correct. Thank you.
Gentleman from Ohio. How is the gentleman from Ohio recorded?
Mr. Shabbat, you're recorded as no.
Mr. Chairman?
The gentleman from Rhode Island.
Mr. Chairman, is it appropriate for us to enter in a colloquy or in the middle of a vote or no?
It's the middle of a vote.
Then how am I recorded? That was what I was going to ask.
Mr. Cicilline, you're recorded as aye.
Thank you. That is correct.
Mr. Chairman.
The gentleman from Louisiana.
Mr. Richmond votes aye.
Mr. Chairman.
Who seeks the gentleman from Maryland.
Could the clerk please tell me how I'm recorded?
Mr. Raskin, you're recorded as aye.
Thank you very much.
Who seeks recognition? How is Mr. Johnson of Louisiana recorded?
Mr. Johnson of Louisiana, you are recorded as no.
For the benefit of members and everyone else present, we have two members coming back from a hearing. We're going to hold the vote open until they get here momentarily.
Okay, never mind.
We're going to hold the vote open until they get here momentarily, hopefully momentarily. People don't have to keep asking how they're recorded. On this vote, everybody should be able to be recorded. The gentlelady from California?
Ms. Lofgren votes aye.
The gentlelady from Washington?
Ms. Jayapal votes aye.
And the two of you are very welcome to cast your votes. Has anyone else who wishes to vote not voted yet? The clerk will report. Yeah.
Mr. Chairman, there are 24 ayes and 16 noes.
The ayes have it, and the committee report as amended is ordered reported favorably to the House. I now recognize the ranking member, the gentleman from Georgia.
Thank you, Mr. Chairman. Pursuant to Clause 2L of Rule 11, I hereby give notice of intent to file dissenting views for the inclusion into the report.
The notice is duly noted. Members will have 2 days to submit views. The committee report will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all of our members for attending. Without objection, the markup is adjourned.